Welcome to the Hindu Daily. We are diving immediately into today's stack of sources, covering everything from complex policy and global affairs to law, science, and public health. Our mission is to extract the most critical insights for you quickly. We are starting straight away with the editorial section and a look at the state of India's courts.
Okay, let's unpack this one first. There's been some talk specifically from Sanjay Sanyal of the PM's Economic Advisory Council, claiming the judiciary is the single biggest hurdle to India becoming Viksit Bharat. That's a pretty strong statement.
It is strong.
Huh.
And the source material we looked at argues this is, well, a significant distortion. It's easy, perhaps too easy, to paint the judiciary as obstructionist.
Scapegoat.
Kind of, yeah. The argument is that this narrative masks deeper issues, failures in how laws are written, and, overall governance problems.
That makes sense. The article actually goes through some specific examples used to critique the courts and sort of flips them, right? Like the claim about Section 12A of the Commercial Courts Act.
Yeah.
The mandatory mediation bit. Exactly. The critique says it's failing, especially in places like Mumbai. But the source argues, look, if the mediation process isn't working, is that the judge's fault?
Or is it the law itself?
Precisely. Judges have to enforce the law as it's written. If the provision itself is flawed, impractical, maybe just badly designed for high-stakes commercial disputes, then the failure lies with Parliament for, well, drafting it poorly, not the judges applying it.
Okay. And what about this 99-to-1 problem? That sounds intriguing.
Yeah, it's a bit vague, but the idea is that laws get overly complicated to deal with, like a tiny 1% exception or edge case. And again, the source says this points back to the legislature.
Imprecise drafting causing downstream problems.
Exactly. It's about the crafting of the law, not necessarily judicial interpretation causing the blockage.
But hang on, even if the cause is legislative, isn't Mr. Sanyal potentially right that the courts are overwhelmed? That the process is a hurdle, regardless of who created the backlog?
Well, yes, the courts are undeniably burdened, but why? The source points a finger directly at the single biggest litigant in India.
Which is?
The government itself.
Yeah.
Union and state governments, tax authorities endlessly appealing routine cases, ministries fighting over simple contracts, public sector units suing left, right, and center. They're consuming vast amounts of judicial time and resources.
Wow. So if the government just managed its own litigation better?
The system would likely see significant relief.
Yeah.
It puts the criticism in a different light, doesn't
It
it?
really does. Which brings us to those persistent stories about judges. Working short hours, taking long vacations.
Ah, yes, those old tropes. The reality, according to the source, is quite different. What you see in open court is just a fraction of the work.
Right.
Judges might handle 50, even 100 cases a day in court. But the preparation, reading thousands of pages, researching precedents, drafting complex judgments that happens late nights, weekends, behind closed doors, it's largely invisible work.
And the vacations.
Often used to clear the backlog of judgments they've reserved. Given the massive caseloads in India, probably the heaviest in the world, and chronic judicial vacancies, those breaks are actually essential for maintaining the quality of justice, not a sign of slacking off.
Okay, one last point from this article. Legislative missteps actually adding to the burden.
Yes, perfect example. The new Income Tax Act. They tried to simplify it by replacing the term notwithstanding, which has decades of case law defining it with irrespective.
Sounds simpler on the surface.
But legally, it's swapping one bit of jargon for another. Notwithstanding had a settled legal meaning. Now, irrespective will probably trigger years of fresh litigation just to figure out exactly what it means in different contexts. It creates uncertainty, not simplicity.
Right, let's shift gears now. Moving to global affairs and the Middle East. There's been some recent optimism maybe around a U.S. peace plan proposal, but this next article is quite skeptical about lasting peace, looking at Israel's conduct since the October 7th Hamas attack.
Yeah, the sources cited paint a pretty grim picture. They highlight specific examples of rhetoric and actions that suggest, well, a strategy based more on overwhelming force and dehumanization than political settlement.
Like what specifically?
Well, you have the far-right finance minister, Smotrich, reportedly calling Gaza a potential real estate bonanza. Then there was former Defense Minister Gallant describing the enemy as human animals. Really stark language.
And didn't Prime Minister Netanyahu reference the biblical story of Amalek?
He did, which in its original context involves destroying everything: men, women, children, livestock. When political leaders use that kind of analogy for a modern conflict, well, it raises serious questions about the actual war aims and whether peace is even conceived as a possibility.
And the article argues this approach, this reliance on brutal force, hasn't actually achieved its main goal.
That's the core argument. The stated objective was often framed as defeating Hamas entirely. But despite Israel's military actions, Hamas reportedly remains the most powerful faction in Gaza, still capable of operating and recruiting. The military strategy hasn't delivered the political outcome sought.
What's really interesting here is how the world is reacting. It seems to be shifting.
Definitely. We're seeing more concrete actions. The European Commission is talking about trade restrictions, possibly sanctions on extremist settlers or ministers. Norway's sovereign wealth fund is divesting from some Israeli companies. Even in cultural spheres like Hollywood, boycott movements seem to be gaining traction.
Is there similar tension within Israel itself?
Yes, the article mentions an opinion poll showing, quite strikingly, 74% of Israelis favoring an end to the war. There's a growing worry, it seems, that the current military approach might actually be counterproductive.
How so?
By potentially driving more Palestinians towards Hamas out of desperation or anger. There's a concern that the doctrine of force alone is creating more enemies than it defeats.
So where does this leave things? The U.S. peace plan is on the table, but
the conduct on the ground, the rhetoric, the internal Israeli debates, and the shifting global sands all cast doubt on its prospects. Even U.S. support, traditionally steadfast, feels a bit more uncertain, especially thinking about potential future political changes, like with President Trump's known unpredictability. The fundamental question remains: can force alone bring stability here?
Okay, moving from global conflict to a complex ethical debate closer to home, in a way, we're looking at the opinion section now, discussing euthanasia reform. This is partly sparked by a proposed law in the UK.
Right, the UK's Terminally Ill Adults End-of-Life Bill. But the Indian context is quite distinct, and it's important to understand that first.
How so?
Well, India legally recognizes passive euthanasia. That means withdrawing life support, like ventilators or feeding tubes, when someone is terminally ill with no hope of recovery. But India consciously draws a line against active euthanasia. That's where a doctor actively administers something to cause death. The law maintains that distinction between letting someone die, omission, and causing death, commission.
But the article argues that even passive euthanasia, though legal, isn't really working in practice.
That's the core problem highlighted. It's legally recognized, but practically almost inaccessible for many. The procedures involve things like advanced directives needing to be just right, getting clearance from 2 separate medical boards. They create these incredibly long, painful delays.
Delays that amount to cruelty for the patient and family.
Exactly. It forces families into this awful position where they might end up making informal decisions outside the proper legal channels just to end suffering.
So why not just adopt something like the UK model, which seems to be moving towards allowing active euthanasia?
The source argues that would be a mistake for India. The UK system relies heavily on the National Health Service, the NHS, providing a baseline of support and palliative care. India doesn't have that kind of uniform, robust public health infrastructure.
And the concern is?
The concern is that with high medical costs and patchy palliative care, legalizing active euthanasia could put subtle or not so subtle pressure on vulnerable people, the elderly, the poor, those financially dependent, to choose death. It opens up risks of coercion.
I see. So instead of expanding the scope to active euthanasia, the proposal is to fix the process for passive euthanasia.
Precisely. Make the existing legal right a practical reality. And the suggestion involves using digital solutions.
How would that work?
Imagine advanced directives registered securely on a national digital portal, maybe linked to Aadhaar for verification, making them easily accessible when needed. Then empower hospital ethics committees made up of senior doctors, a palliative care expert, maybe a neutral outsider, to authorize withdrawal of life support much faster, say within 48 hours, based on clear criteria.
Would there be safeguards?
Absolutely crucial. The proposal includes mandatory safeguards. A cooling-off period, maybe 7 days, psychological counseling for the family and patient if conscious, and a mandatory review by palliative care specialists.
So it's about making the existing compassionate option workable.
Exactly. It aims for dignity in dying within the current ethical framework, making the legal pathway accessible without introducing the risks that active euthanasia might pose in India's specific socioeconomic context.
All right, let's switch to the science section now. This piece looks at something called Jugaad science. I love that term. It's about researchers, particularly in places like Kenya and India in the global south, finding these clever workarounds for big obstacles.
It's a great term, isn't it? And what's really striking is that the biggest hurdles these scientists face often aren't actually the science itself. They're bureaucratic, administrative, financial.
Like what kind of things?
Oh, the things like incredibly opaque approval processes, multiple government agencies needing to sign off, sometimes getting verbal instructions that contradict the written policies. The article gives an example, waiting 8 months just for a permit to enter a protected forest area in India for research. 8 months.
Wow. Yeah, that would kill any research momentum.
Yeah.
What else?
Procurement is another huge one. Rigid rules often force them to buy the absolute cheapest option, the L1 tender, even if it's totally unsuitable. Imagine needing a very specific, high-quality chemical reagent that only one company makes, but being forced to buy something cheaper that won't work just because of procurement rules.
So how do they cope? What's the Jugaad?
Collaboration becomes absolutely key. It's the main strategy, the main workaround.
How does that help with bureaucracy?
Well, they've developed clever ways. For instance, instead of waiting potentially years for a formal memorandum of understanding and MOYO to be signed between institutions.
Which can get stuck in ministries forever?
Right. They might use informal frameworks of collaboration to just get the work started while the official paperwork slowly grinds through the system.
Smart. Any other collaboration tricks?
Yeah, linking student training directly to research funding. So they might propose a project where, to make it viable, the budget has to include stipends or fees for students. It helps get the research done and supports emerging scientists. Double win.
That is clever. Addresses two problems at once.
Another big one is leveraging international partnerships for resources. Instead of trying to buy, say, an expensive DNA sequencer that costs tens of lakhs and might be outdated in a few years.
They ship samples.
Exactly. Ship the samples to a collaborator's lab abroad that already has the cutting-edge equipment. It's way more efficient and cost-effective long-term. The overall message is really a call for more South-South collaboration, too.
Because researchers in Africa and Asia face similar hurdles.
Precisely. They understand each other's constraints and could pool resources, share solutions. And the data backs this up. The article mentions that collaborations, especially international ones, lead to more impactful research. Like nearly 2,100 papers co-authored between India and U.S. institutions in agricultural sciences alone. Collaboration works.
Okay, let's turn to text and context now. This first one is really interesting, quite controversial maybe. It's about the Delhi High Court allowing civil lawsuits for something called alienation of affection, suing your spouse's alleged affair partner.
Yes, that's the gist of it. Alienation of affection, or AOA, is an old common law tort. It's sometimes called a heart balm tort.
Heart balm.
Yeah, meaning it's supposed to soothe the broken heart, metaphorically speaking. It allows a spouse to sue a third party, the alleged lover, for intentionally interfering in the marriage and causing a loss of, well, affection, companionship, a whole marital relationship. The legal term for that bundle of rights and companionship is consortium.
Consortium. Got it. But isn't this kind of lawsuit mostly abolished elsewhere? I thought the U.S. largely got rid of these.
You're right. Most U.S. states have abolished AOA laws. They're often seen as outdated, based on archaic ideas about marriage, and potentially misused for blackmail or harassment. Though a few states do still retain them, interestingly.
So why is the Delhi High Court reviving it, or at least allowing it, especially after the Supreme Court decriminalized adultery?
That's the crucial link. The Supreme Court's Joseph Schein judgment in 2018 struck down the criminal offense of adultery. The court said marital relations and choices are a matter of intense privacy. However, the Supreme Court was very clear. Decriminalizing adultery doesn't mean it has no consequences. It explicitly said adultery remains a civil wrong and a valid ground for divorce.
Okay, so not a crime, but still a civil issue. How did the Delhi High Court connect that to suing a third party in this Shelly Mahajan case?
The High Court reasoned that while Joseph Schein removed the criminal penalty, it didn't give anyone a license for extramarital relationships free of civil or legal implications. And since existing marriage laws, like the Hindu Marriage Act, mainly provide remedies between the spouses, divorce, maintenance, they don't address the injury caused by third-party interfering.
So the court saw a gap.
Essentially, yes. They ruled that since there's no law specifically barring a civil suit against a third party for the tort of intentionally interfering with the marriage, that legal avenue remains open.
But isn't there a huge risk of vexatious or abusive lawsuits? How did the court address that?
They were very aware of that risk. That's why they laid down a strict three-part test that someone bringing an AOA claim must meet.
What's the test?
First, you have to prove intentional and wrongful conduct by the third party, specifically aimed at breaking up the marriage. Second, you need to show clear causation that this specific conduct directly led to a legally recognized injury, the loss of consortium. And third, the loss claimed must be something a court can rationally assess in terms of damages. It's a high bar.
And one final point, these cases go to civil courts, not family courts.
Correct. The High Court clarified that because the lawsuit is against a third party for an independent civil wrong, the tort, not a dispute between the spouses about the marriage itself, like divorce, it falls under the jurisdiction of the general civil courts. It's a significant ruling on the available civil remedies following Joseph Schein.
Okay, our final piece today, also from Text and Context, dives into health. A study linking common mouth bacteria directly to heart attacks. That sounds alarming.
It is quite remarkable research, published in the Journal of the American Heart Association. A team in Finland found specific bacteria, viridans streptococci, which are actually very common in our mouths, deep inside atherosclerotic plaques.
Plaques being the fatty deposits that clog arteries.
Exactly. These bacteria form sticky layers, biofilms, inside these plaques. They found them in about 42% of the coronary artery samples they examined, both from autopsies and surgeries.
And they're not just passive bystanders. The study suggests they actually trigger the heart attack.
That's the key finding. The bacteria seem to hide out silently in the core of the plaque, shielded from the immune system. But when the plaque becomes unstable and starts to rupture, which is the event that causes most heart attacks, things change.
How?
The bacteria shift towards the outer layer of the plaque. There, they activate something called TLR2, which is like an immune system sensor, a tripwire. This activation triggers intense, localized inflammation right at the rupture site.
Making the rupture worse, leading to the clot.
Precisely. The inflammation destabilizes the plaque further, leading to the rupture and subsequent blood clot that blocks the artery, causing the heart attack.
This raises a big question, though. If bacteria are involved, why haven't antibiotics worked well for treating or preventing heart disease in big trials?
That's puzzled researchers. The theory this study supports is, it's the biofilm. Bacteria embedded in these dense, sticky biofilms are incredibly resistant. They can shrug off antibiotics and evade immune cells much more effectively than free-floating bacteria.
So the infection just persists quietly inside the plaque.
Like a hidden, smoldering fire, making the plaque vulnerable over time. A ticking time bomb, essentially.
This really underscores the importance of oral health, doesn't it? It's not just about teeth and gums.
Absolutely. The link is becoming clearer. The article mentions the large Eric Henry study, which found regular dental care was linked to a 23% lower risk of stroke. It's why dentists are so insistent about treating gum disease, abscesses, any chronic dental infection promptly. Those bacteria have a direct route to the bloodstream and, potentially, the arteries.
Are there potential future treatments based on this?
Well, it opens up possibilities. Maybe measuring the oral bioburden, the amount of these specific bacteria in high-risk heart patients, perhaps targeted preventive antibiotics, similar to how penicillin is used to prevent complications from rheumatic fever.
Or even a vaccine?
Potentially, down the line. A vaccine against the bacteria's ability to form biofilms or trigger clotting could be conceivable. This connection is particularly relevant for India, the article notes, because cardiovascular disease tends to hit younger people here, and untreated oral disease is unfortunately very common. So just a final thought to leave you with. If we accept the argument that legislative flaws and government actions, not just judicial delays, are major roadblocks to India's progress, how much should we shift our public conversation? Away from just critiquing court outcomes and more towards scrutinizing and fixing the fundamental process of how laws are made and how government itself operates within the legal system.
Thank you for listening. If you want to provide suggestions, please contact on the Twitter handle given in the episode description. As always, we are eager to hear what our listeners want to be informed about. We wish you a great day.